I get a lot of questions about trademark law, so I thought I'd take a little bit of time to answer some of them here. Hi, I'm Gordon Firemark, and this is Asked and Answered, where I answer your entertainment and intellectual property law questions so you can take your career and business to the next level. Stick around. Okay, so you've spent a lot of time and energy and maybe a lot of money to build a brand for your business. You've landed on a name or a logo that really captures the true essence of your products and services. It immediately conveys all that important information that's going to draw your audience in and help persuade them to purchase your product or service from you. You've got this strong brand, so it's worth protecting. How would it affect your business if a competitor opened up shop with a similar or nearly identical name? How would it affect you if, just as you're poised to expand into a new geographic area, you learn that your brand is already being used by a similar business? Or how would it affect you if an existing company already using a similar brand in other places expanded into your market? Well, all of these things can be avoided if you take the steps early on that you need to protect your brand. The most important of these are to, first, select your brand carefully, use the brand consistently as a trademark, and register the trademark. So what is a trademark? Well, a trademark is a word, a phrase, a symbol, or a design, or a combination of words, phrases, symbols, and designs that identifies and distinguishes the source of the goods of one party from those of others. Because a trademark has to be distinctive, it's important to select your brand wisely. Generic and primarily descriptive identifiers can't be protected by trademark law. So, for example, calling your product Lasting Taste Gum might be very useful in attracting customers, but it won't be protected, at least not until it has acquired distinctiveness by becoming so popular, so well known, that the name Lasting Taste Gum has a secondary meaning with consumers. That's why brands like Payless Shoes or Double Mint Gum are able to be protected. It's better, for trademark protection purposes at least, to select a brand that is inherently distinctive. Coined and fanciful and suggestive brands all fall on the more distinctive end of the spectrum, and they're entitled to protection. Brands like Xerox, Google, Kleenex, these do very little to describe the products and services to which they're attached, but they convey the most important information, the source. The consumer knows which company stands behind these products and services that are marketed under those brands. So what does a trademark protect? Well, the owner of a trademark is entitled to the exclusive use of that brand in the particular category or categories of goods or services that the owner sells. Competitors will be barred from using any confusingly similar branding to identify their goods in those same categories. So, for example, the maker of tape and adhesive products probably wouldn't be able to use the brand Scotch or anything confusingly similar, like an alternate spelling of the word Scotch or something, because 3M's trademark for Scotch tape prevents this. And the same is going to be true for that plaid design that they use, which is also a registered trademark of 3M. But if a guy named McDougall wants to start manufacturing, power drills under the name Scotch in honor of his Scottish heritage, he probably will be permitted to do so, because it's not in the same category of goods and services. So how do I get a trademark? Well, generally speaking, trademark rights are earned by using the mark. The first person or business to affix a mark to goods or services and to advertise and market them in commerce gains the exclusive rights of a common law trademark. If that use is purely local, then the scope of the trademark rights is going to be just as local. Now, many states have adopted trademark registration laws that permit protection to be extended sort of statewide. But if a business markets its goods or services across state lines, that is, throughout other parts of the country, it is engaged in interstate commerce, and thus it's subject to federal law. Under the so-called Lanham Act, trademarks, marks that are used in interstate commerce, are entitled to federal protection, and they can be registered with the U.S. Patent and Trademark Office. This registration system provides for constructive notice of trademark ownership and remedies against infringers. Registering a trademark isn't difficult, but it can be rather technical. Unlike registering a copyright, which I often just recommend my clients handle themselves or in-house, trademark registration can have hidden complexities, mostly to do with properly classifying your goods and services to give you the greatest flexibility and protection. So for this reason, I recommend against the do-it-yourself approach with trademark registrations. The government's fees for registration start at around $300, and they can increase according to the number of marks and logos and the number of classes of goods involved. Now, all of this money can go to waste and be forfeit if the application isn't prepared and prosecuted properly. In fact, it's not at all unusual for trademark applications to be initially rejected by the examining attorneys in the trademark office. And in that case, it then becomes necessary to prepare a responsive legal argument in favor of the registration. My experience is that do-it-yourselfers often wind up hiring me or another lawyer at this stage, and they wind up paying much more than they would have invested initially to have a lawyer prepare the application and get it done right. Your brand name is likely one of your most valuable assets. It makes sense to take measures to protect it and your business against unfair competition from competitors. Trade or service mark registration is among the best way to secure that protection. But before you jump onto the Trademark Office's website, it's a good idea to consult with an experienced intellectual property or entertainment attorney and make sure you've got all your ducks in a row. If you like these videos, please subscribe to my YouTube channel, and if you have a question you'd like me to answer, head on over to firemark.com/questions. See you next time.